We in Guyana are still victims of the remnants of enslavement, colonization, and I dare say have found ourselves in the state of neo-colonialism, all of which embraced elements that are discriminatory in relation to the people of African descent in particular. And that alone gives reason why the second decade is very much applicable and relevant to the Ghana situation. But not only do we have remnants, those systems which have been referred to, but we also are actively suffering from infringements of the Universal Declaration of Human Rights. For example, we suffer from infringements in relation to freedom and discrimination. We see this in the realm of the public service, security forces, the award of contracts, and evolving our life. Article 3, that declaration. There are continuing problems of extrajudicial killings, adding victims to those who over the years have so suffered. We've also seen that Article 5, which speaks about freedom from torture, continues to be breached here in Guyana. And similarly, Article 6, the right to recognition before the law, and Article 7, the right to equality before the law, Article 8, the right to remedies, and the right to a fair trial. All of these, there are actions that are taken which are quite contrary to what those rights provide for. We have instances of the weaponizing of and denials of justice through political manipulation of the administration of justice. The need for reform in our justice system. And one can easily quote the example of IDPAD-G itself, which on one hand has been denied, on the other hand, having brought this matter to the court, the decision seems to be languishing since this matter was brought in 2023 after the suspension of the subvention in 2022. But that has to be taken also in the context of the manner in which the judiciary itself is being treated, the continuing denial of the appointment of the Chancellor and the Chief Justice, and the whole question of equitable access to justice. It's one thing to speak about justice, it's another thing to speak about equitable access to justice. And the fact that our system of justice has retained a lot of anachronistic legal procedures that impede the adjudication of the substantive issues, thus denying justice where it is evidently being observed in the breach. One can look at the plethora of cases, even constitutional cases, which have been determined on procedural grounds rather than the substantive matters being addressed. These are all remnants of the old system we've referred to, remnants of the system under enslavement, under colonialism, and evidence of a new colonial state, which we are subjected to. The issue of the right to property under Article 17. We have glaring instances, the violation of those rights, with good examples in terms of what has happened on the Mocha corridor, the Mocha-Arcadia corridor, where people of African descent have been bulldozed and removed from lands under the pretext that those lands were to be used for the construction of a road, which has since been constructed, has evidently not been constructed on those lands, although government officials continue to say to the public with a bare face that the road is traversing those lands. And physical evidence is there to show that they are prepared to spew lies in the face of acts of discrimination. And so we come also to Article 19, issues of the right of freedom and opinion of expression. And we know what threats have been meted out to social influencers and to others, only for freedom of expression, to the extent that there are those who have been brought before the courts under the so-called Cybercrime Act. Continuing problem can be identified with Article 25, the right to adequate standards of living, right which continues to be infringed and entrenched if only one looks at the recently read budget. That is certainly not pro-poor and therefore not providing for adequate standard of living of the ordinary man. And the right to education as well, not only from the standpoint of access to education, but from the standpoint of the quality of education which is being meted out. And so one can easily understand and see the application of the second decade to the people of African descent in Guyana. Not only because of the breach of those rights, but because of the attitude of the government. We have a government that contends, in fact, that there are no peculiar, specific, historic problems that are affecting the people of African descent, and that the people of African descent have access, like everyone else, to all that's available. And therefore, one cannot identify a program, specific program, that the government has articulated for the people of African descent, notwithstanding the call by the United Nations for such a program and the evidence in Guyana that there is need for such a program. Program which should not only speak to economic issues, but should speak to what the Declaration has repeated, and that is the issue of the existence of institutional and legal barriers to people being able to realize their freedom and to realize their very being. We have lots of institutional arrangements, be it in the police force, which was formed when it was formed as a force, not as a service, be it in the health sector, which does not pay sufficient attention to the historic issues, dietary issues, and other issues that affect the people of African descent. And so we can go across the various institutions in this country. And as we go across those institutions, we can see that they have not been geared to address the issues affecting the people of African descent, although the government at the same time would contend that there are no such issues and that there's no need for special attention, even as they give handouts to some of the people of African descent to be engaged in programs that in no way addresses what the decade calls for.